Welcome to the GTEN Land Patents Course. For those of you who don't know me, I think a lot of our members here are recurring, but my friends and associates call me Christian. I'm a trustee of GTEN. Michael is running the show here. PJ is not going to join us tonight, but may join us at a later date. Welcome to GTEN Land Patents. This course is a workshop to bring forth the land patent for allodial title to your land. We'll create a brain trust together to examine the law and authority for a complete understanding of your right, title, and interest. Then we'll perform the land patent procedure with the GTEN members' land in real time. We'll finish the course with a complete set of all the documents and the experience of having done it together. I think it should be really fun and interesting. Couple of announcements. If you because I don't have PJ to talk to on this call, if you want to talk to me, just raise your hand and we will unmute you so you can ask a question. And then we'll have a question and answer period at the end in any case. So you can also just hold your questions if you like. We've got everyone muted out, just so there's no background noise, and we'll unmute you if you raise your hand and we can talk to you. Okay, let's get into it. Let's take a look at a land patent. So this is a sample land patent, randomly selected from the internet. It's the whole land patent on the left. It's just a one-page document. And on the right, we've got the top half. And what I want to point out in here is that there is one particular word on this document that matters a lot. And we're going to look at it very closely. But whereas there's been a deposit in the General Land Office of the United States, a certificate of the Register of Land Office at blah, 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 where it appears pursuant to Act of Congress approved 20th May, 1862, to secure homesteads to actual settlers on the public domain, and the acts supplemental thereto, the claim of that name has been established and duly consummated in conformity to the law for, and then it's the metes and bounds, identifying the land. And let's look at the second half. According to the official plat of the survey of the said land, returned to the General Land Office by the Surveyor General, now know ye that there is land therefore granted by the United States unto the said person, tract of land above described, to have and to hold the said tract of land with the appurtenances thereof unto the said individual and to his heirs and assigns forever. That's the word. All right, forever. The theory of the land patent is that it is a forever grant and assignable forever. Okay, at no point in there does the government ever get it back. All right. Signed by Theodore Roosevelt. That's pretty cool. All right. And this is pretty typical of what land patents look like. It's pretty standard. Okay. Let's look at the next slide. So this was in the materials that we sent out about the course. It's the theory. The theory is that there's perfect allodial title granted by a land patent. It's an entire transfer of ownership by law. And it's assignable to you. It's yours and assignable to your heirs, successors, or assigns forever. There's that word again. It eliminates split title, which we'll talk about more. It negates county assessor's claims, prevents seizure for unpaid property tax, prevents seizure by foreclosure. The land cannot be liened or levied and cannot be trespassed upon. It defeats zoning regulations. It defeats use restrictions, except those that are a direct threat to public health and safety. It prevents unwanted easements. It removes jurisdiction from state and federal courts. It passes to heirs without probate, applies to residential, commercial, and investment land, works whether mortgaged or not, and is applicable in all of North America, as well as some of the crown colonies in many countries. And I think it's important to note that, at least in my worldview, It is lawful, ethical, moral, and right. It's the right thing to do. And we'll talk about why that is as well. That's the theory. Let's talk about the reality, because we would like to think that the reality is the same as the theory. We're going to get to the bottom of the land patent theory. We aren't recommending anything, promoting the idea, or suggesting you take our word for anything we discuss here. Our mission is to find the truth through this workshop so it's usable, so that then you can proceed with whatever you think is right. This sort of level of scrutiny and truth seeking and myth busting is what we do here at GTEN. We apply this practice to everything we teach. This course is a workshop to drill down to the truth and do the process together. It provides the opportunity for you to go through it without risk to your own property. Then you can make an informed choice of whether to apply the process to your own land. We think that's a great opportunity. We're looking forward to going through it. And there's an ulterior motive here as well, somewhat akin to when we taught the right to travel course. It was never very important to us whether people choose to travel by right or drive with a driver's license. The whole course was sort of a proxy for understanding who you are, rights as opposed to privileges, and jurisdictions, and the many hats that you wear by adhesion contracts and hidden contracts. So, what we want with this course is similar. We're living in interesting times, to say the least, precarious times as well. And we think it's a great time to be curious, ask questions, trust yet verify, and to look for answers in the form of better questions. Those are always the best answers. So we're going to be looking for better questions throughout this, especially today. Is about the questions. It's more about questions than answers today. And then then we'll know what we need to drill down to find out. These times call us back to GTEN, to reunite and unify us, to make sense of the world as the veil is lifting and the pace of technology is ever increasing. This course is about critical thinking to inform our individual and collective choice making. I've selected some words from the late Terence McKenna. I'm a big fan. He was a critical thinker, a good writer, and an amazing orator at the forefront of spiritual wisdom. His theory of novelty, something he was working on for the last decade or two, actually, of his life, has to do with an ever-increasing pace of complexity in human existence. It took 20,000 years for early civilization to double in its complexity. In the Middle Ages, it took hundreds of years to double in complexity. In the 1900s, it took probably about 50 years for complexity of our civilization to double. And now that we have AI is setting the pace for novelty. So things are going fast. And it's a great time to be paying attention. The last doubling of AI computing power took 5.7 months. That's a 2x, right? That's doubling computing power. And it compounds like that more than twice a year right now. And that interval is decreasing with each generation of new AI. So the next doubling of compute will take about 4 or 5 months. And the one after that, probably a month less. And, and each time the computing power is doubling. Exponential growth at an ever-increasing pace toward a singularity of novelty and complexity. That's McKenna's theory, which I think we're seeing playing out. His words were prophetic. It's a very important time to know who we are, that we are infinite energy. We're energy beings having a human experience. I find McKenna a source of great wisdom for these times, which he very clearly foresaw. Times we're now living, and the need for critical thinking, both independently and collectively, to inform good choice making is now more than ever. This course is about critical thinking, in my view. There are other people out there telling you how to do land patent retrievals. One in particular is very good, Ron Gibson, and we're going to be looking at his work. Ron, unfortunately, just suffered a heart attack, so I hope he's going to be okay. I hope he's still with us. I haven't heard yet, so it just happened. But this is, as we look to what is the reality, we're going to apply critical thinking with proper research using authoritative source material. And we're going to look at every angle of this that we can think of so that all of us can make the choice together and for ourselves. You have to take seriously the notion that understanding the universe is your responsibility, because the only understanding of the universe that will be useful to you is your own understanding. Half the time you think you're thinking, you're actually listening. Like those doing their thinking by watching, MSNBC or CNN or whatever, or reading the New York Times. You think you're thinking, but you're actually just inputting. And it's very important to choose your sources that you input from and do your own critical thinking. Television is by nature the dominator drug par excellence. Control of content, uniformity of content, repeatability of content make it inevitably a tool of coercion, brainwashing, and manipulation. We see it every day. The syntactical nature of reality, the real secret of magic, is that the world is made of words. And if you know the words that the world is made of, you can make of it whatever you wish. With that, we're going to take a good look at the pertinent words for allodial title. When we do this, we're going to focus on authoritative sources as much as possible. Now, those who've been with us before know what we think is authoritative. Where law is concerned, the 4 organic laws of the United States of America, the country, right? Not the statutes and code and regulations of the corporate US. Same is true in most countries. If you look back to what's actually law versus what's legal land, that distinction is very important. All right, let's jump into definitions here. Where words are concerned that aren't, so let me just finish that. The four sources. So my favorite is the Declaration of Independence. And the United States of America, that's the first set of laws, the first organic law. There's also the Northwest ordinances, and there's the Articles of Confederation, and there's the Constitution. So those 4 documents are all we have for law in the United States of America. Then there's the interpretation of those laws by the Supreme Court when it convenes in Article 3, which means when it's considering rights of the people. In those circumstances, well, first of all, that the Supreme Court law is the law of the land. Its interpretation of the 4 organic laws is, form the law of the land. Nothing else matters if you bring that into court. So we'll always look most strongly at Supreme Court law, United States Supreme Court law. When they have rights cases in the Supreme Court, they don't use Black's Law Dictionary as the first choice of definitions. because Black's Law is a book of terms. It redefines the words into legalese. And it's actually part of the problem that we face as sovereign people. We don't get to see the real meaning of things unless we dig deeper. So Webster's is a first go-to for definitions for meanings. So it's a book of word meanings, as opposed to Black's Law, which is a book of terms, the defined terms in the social contract. All right. So look at Black's Law if you want to know what the court's talking about. Look at Webster's if you want to know what the four organic laws are talking about. And the older the version of the dictionary, the better. If you can look at the dictionary from back when the organic laws were written, that those meanings carry more weight. From there, we also like etymology. Etymology, the original meaning of words, the source of meaning, is pertinent. But we stay away from things like Wikipedia. Wikipedia is a consensus view. In its origin, at least, it was a consensus view. And they weight the consensus to those who know what they're talking about, hopefully, more, have more weight than those who just, want to talk conspiracies or whatever. But even that consensus view, which is not authoritative, by the way, a consensus view is never authoritative. But even that consensus view has been undermined, co-opted, and now Wikipedia is controlled. So Wikipedia is a terrible place for anything other than when was Robert De Niro born. I'll look at it to see, who is this person? Oh yeah, that's right. That's the French prime minister or whatever. France doesn't have a prime minister. Anyway, you get the point. AI is another one of those. It's a consensus view at best, and it's also controlled. What it's allowed to look at, what it's trained on, matters. So AI is becoming a very powerful tool, and we're going to use it in this course. But we're going to use it in a way that shows how it can be used well, and we're not going to rely upon its answers. We're going to use it to find sources that are authoritative and go to those sources. Okay, here's our friend sovereignty. This word has definitely been co-opted by the sovereign citizen devil, theory of the deep state and police and governments. Sovereign's a great word. Sovereign is what the people of the United States were at the time of the formation of the country. We chose not to have a monarch, not to have a king or a queen. And we chose that the people were king and queen. So sovereign is an important word in this. And let's take a look at the etym online. Okay, sovereign, superior, ruler, master, one who is superior to or has power over another. Old French sovereign. Sovereign, lord, ruler. Highest, supreme chief. Okay. Let's scroll down a little bit, see if there's any more I need to look at there. Okay. That's good enough for that. Let's look at the definition of Webster's. A supreme power, especially over a body politic. Freedom from external control, autonomy, controlling influence. So sovereign or sovereignty refers to the fact that there's no overlord, there is no controller, there is no master. One who is sovereign has no one to report to. Okay. You can contrast that with subject, right? Subject to. If you're a subject, or a citizen is a subject, right? So if you're a citizen, you're a subject, and you're subject to the government and other things, the rules, regulations, codes, statutes, all of the legislative stuff, all of legal land. You are a citizen subject. A sovereign forms the government, which makes the laws. A subject is a legal fiction formed under the law, formed by the law. And so a reality can make a fiction, but a fiction can't make a reality. When the people, a reality, make the laws a fiction, and the laws make a person, like the 14th Amendment citizen, subject, that can only be another fiction. That can't be a reality. So the choice here is whether you're going to stand as a real living man or woman, a free inhabitant, or you're going to be subject to the government as a citizen subject. Okay. Real estate versus land. They are not the same thing. Let's start with real property. Property. Something as land, goods, or money that is owned, especially a piece of real estate. Estate. We'll go to 4A, the degree, quality, nature, and extent of one's interest in land or other property. 4B1, possessions, property, especially a person's property in land and tenements, or land with a house on it. Okay. So it's let's look at these again. Something that's owned, property. An estate is the way it's held. Land, on the other hand, the solid part of the surface of the earth. Ground or soil of a specified situation, nature, or quality, the surface of the earth and all its natural resources. Number 2, a portion of the earth's solid surface distinguishable by boundaries or ownership. See the difference in quality of these words. One of them is property owned, real estate. Land is meets and bounds a piece of the earth. And it, I don't see it here, but it includes, oh, there it is, 1C, your surface of the earth and all its natural resources. So it's the surface and what's below it and above it, the air, the minerals, the water, the soil, the rock, etc. Right? So it is a measure of the surface of the earth, meets and bounds, with everything above and below it. It's a 3-dimensional thing, in fact, land is. Whereas real estate is actually a fictitious overlay called a plat map. And really only pertains to the structures that are on it, as well as that plat map. So it's a legal fiction that's owned when you own real estate and transferred when you own real estate. And when we're talking about the transfer of land, talking about dirt, and everything in and above it. Very important distinction. Okay. Feudal versus allodial. It's basically estate versus land. Feudal refers to the estate, the real estate. Allodial is titled to land. Pertaining to feuds, estates of land granted by a superior on condition of services to be rendered to the grantor. One who holds lands of an overlord in exchange for service. How do we go back, Michael? Okay. That doesn't sound like the way I want to hold property. It is the way we hold property in this country, and at one time, it was in Europe, it was the way land was held. But we fought multiple wars in the United States of America, including 1776 and 1812, to get rid of the feudal concept and have instead the right to own land, as opposed to the privilege of squatting on someone else's land, which is what feudal is. Fee, an estate and land held in feudal law from a lord on condition of homage and service, or two, a piece of land so held. B, an inherited or heritable estate in land. So an estate in land is not land, right? We've already covered that difference. Land is dirt. An estate in land is ownership of paper. Let's contrast that with allodium. Now, allodium, sometimes spelled with one L, sometimes two. Typically, you see it with two L's. We're all the same word. And sometimes, you can actually talk about allodium without the A or the first L. So they're all the same thing. One, a form of estate among 11th century Anglo-Saxons in which absolute possession and control were vested in the holder, opposed to feodum, which is feudal, right? Usually allodium is how you spell it. Land that is the absolute property of the owner. Real estate held in absolute independence without being subject to any rent, service, or acknowledgement to a superior. Okay? No rent, no service or acknowledgement to any superior. Absolute independence. So allodium is pure title. It's perfect. It's perfect title. Okay. Which brings us to legal versus equitable title. Let's take a look at that. First of all, just title. Let's go to 6A. A legally just cause of exclusive possession. B, the instrument such as a deed that is evidence of a right. C, all the elements constituting legal ownership. And let's keep in mind there are multiple kinds of title here, right? There's allodial, there's feudal, and within feudal, there's equitable and legal title separated. That's the split title in the feudal system. Okay, that's enough. So split title, as I just mentioned, is when, in the case of, say, a mortgage, you have the usufruct as the mortgage signatory, right? You issued the note and signed the mortgage and got a warranty deed. And that warranty deed gives you warrants that you have the usufruct, which is the equitable title. You have the use. But if you look at the language of a warranty deed, you're a renter. If you look at the language of a mortgage, you are a renter on your own land. You're a tenant, is the way it's described, not an owner. That's because the legal title lies partly at the bank and partly at the county. So it's actually kind of split three ways. The county and the bank both have claims of legal title, and you only have the usufruct. Okay. Allodial title, by contrast, is title to the land itself, not to an estate or interest in the land. It's absolute perfect title to land, no split title. All right. So a real estate deed, also known as a warranty deed, is paper. It's a receipt, physical document signifying ownership only, though, in split title form. Right? It's feudal. That ownership is in quotes. It's really tenancy. It's a feudal system document, and what it shows is the usufruct or equitable title. Land patent. This is where things start to get more interesting. Also called letters patent, same thing. It is sovereign rights, which is why we started this thing with sovereignty. The sovereign, I'm not going to say above the law, because that's not the point. The sovereigns create the law, which create the subjects, right? So if you know how to stand as sovereign, your letters patent or land patent conveys right, title, and interest in interesting ways. Letters patent, a writing as from a sovereign that confers on a designated person a grant in a form open for public inspection. Okay, in this case, the sovereign they're referring to is the country, right? The sovereign confers on another sovereign a grant, and it's open for public inspection. And that's going to be important when we go to claim the land patent, because we're going to let the public inspect what we're doing. We have to give notice, and we will. And the public will have a chance to inspect what we've done. Okay, that's enough of that. Okay. Whoops, how did I get there? That's not what I was expecting. Okay. Sorry, 1 second. I've kind of lost my place here. Oh, well, that went quickly. All right. So this is where we were planning to take a break. It went more quickly than I expected, which is fine. That's probably because we don't have the typical banter between me and PJ that is interesting and fun, but tends to slow down our way through the slides. What I would like to do is take a short break. I'm going to leave this up on screen and let you guys look at it. Let's come back in just 10 minutes. And I've got a couple of bugs I want to work out on our tech here. If you've noticed any problems with the delivery of this so far, please put it in the comments. Please write it into the comments. And then we will be back in 10 minutes. That'll be 10 minutes up before the hour. Thanks. We'll see you then. And we're back. I went through that pretty quickly. I'd love to slow down for a minute and see if anyone has questions. There is a comment made by someone identified as only guest. Fee simple absolute. Yeah, let's put that on. Is that what's showing to the crowd right now, or the audience right now? All right, here's the Google AI overview of fee simple absolute. The most complete form of property ownership, granting the owner full rights to use, sell, lease, or transfer the property without restrictions. It's essentially outright ownership with no conditions or limitations on how the property can be used. Further breakdown, absolute ownership. The owner has the right to possess the land, use it, sell it, or give it away without limitations, except for those imposed by law, like zoning or taxes. Here's where it gets sticky. So fee simple absolute is actually a feodum term, right? It is feudal. It looks like a allodial title, but it's not. It's used in both realms. Let's put it that way. But remember, fee is an estate in land or an estate in property, right? So fee simple absolute sounds good, but it's not allodial, because zoning and taxes come from legal fiction land and not from law. So it should say except for those imposed by legal land or law, right? So that's something I'm glad it was raised. It's important to watch the language very carefully. You'll see when you look up land patents online or whatever, you'll see it defined, a land patent defined as a fee simple absolute title, but it's not. Okay, and we're going to break down in that on that subject more in this next little section here. But I wanted to bring that up. Do we have anyone have any questions about any of these definitions of words? I almost said terms. They're not terms, they're meanings. Anyone have any questions about any of these meanings? Because these are foundational, and I think I went through them fairly swiftly compared to past presentations we've done. So feel free to raise your hand and ask questions. And if there are none, we'll move on. But I'll presume if there are no questions to that we're good. Okay, don't see any. If any come up for you, just raise your hand and we'll call on you. Nature loves courage. You make the commitment and nature will respond to that commitment by removing impossible obstacles. Dream the impossible dream and the world will not grind you under. It will lift you up. This is the trick. This is what all these teachers and philosophers who really counted, who really touched the alchemical gold, this is what they understood. This is the shamanic dance in the waterfall. This is how magic is done. By hurling yourself into the abyss and discovering it's a feather bed. Long quote, but perhaps Terence McKenna's most quotable. It really shows where he's coming from, and I love it. He's an ethnobotanist, which basically means he's a psychonaut. He believes in the plant teachers, as do I, and we have a lot to learn from them. And this is his worldview in a paragraph, and I just love this quote. Okay. Basis in authoritative law. Treaties are the source of all American land ownership and most land ownership globally. The property is conveyed on behalf of the people, not on or for the government. It's the source of the rights, title, and interest and authority and jurisdiction. It's the whole 9 yards that gets passed along intact by the land patent. But the thing about treaties is that all countries and their people must honor treaties worldwide, right? And those people must be honored in those treaties worldwide. Violation of a treaty is tantamount to war. So treaties are the highest form of global law. You get that? If we didn't have treaties, we'd be at constant war. Well, we kind of are anyway, but the point is that treaties end wars. Let's look at the definition or the source of the meaning from Edom Online. Treaty, late 14th century, discussion, negotiation, agreement, contract, or accord. From the Anglo-French, traité, assembly, agreement, dealings. From the Latin, discussion, handling, management. To handle, manage, to treat. The sense of a contract or league between two or more nations or sovereigns, solemnly ratified by the supreme power of each. And that's the people, at least in the United States of America and many countries, that's the people. Okay, it's a discourse that resolves ownership. Okay. So as examples, the War of 1812 ended with the Treaty of Ghent. And that treaty solidified the American ownership of land as opposed to the British. All right. The Mexican-American War ended with the Treaty of Guadalupe Hidalgo. And that was a deal with Mexico for $15 million to buy basically the entire Western United States. Good deal. I think we've made use of that. These treaties are the highest form of law, as we discussed. And as such, they convey the law of the settlement of war to the people, and the people, and held by the government for the people, and then parceled out to the people by land patents. Okay, the rights of the people were conveyed intact from the treaties by land patent, undiminished, forever. I should have put that word in here again. It's such a good word, forever. This is a map of some of those treaties. You can see in pink on the left, the Mexican cession, 1848. That's the Treaty of Guadalupe Hidalgo. On the right, territory of the original 13 states. That's the Treaty of Ghent from the British. Texas was annexed separately. Louisiana Purchase was bought, but also created a treaty with France when it was purchased. At the top there, you see a British cession of 1818. And then the Oregon Territory was a treaty with Great Britain in 1846. There are different pieces here, but all of them come by treaty, every single one of them, whether purchased or won by war, usually a combination of the two. These are all land gained for the people of the United States of America, the country, by treaty, with all right, title, and interest intact. Okay. Vested rights. These are what are conveyed by treaty, and these are what are conveyed intact by land patent. Let's look at vested rights. A right belonging completely and unconditionally to a person as a property interest which cannot be impaired or taken away, as through retroactive legislation, without the consent of the owner. So when a right is vested, no retroactive legislation can change it. Very important, right? If the treaties conveyed rights and the land patent conveyed all those rights intact, then legislation that came later has what effect? Unless the owner consents, it cannot be impaired or taken away. The property interest cannot be impaired or taken away. Authority and jurisdiction. We started with the word sovereign. You know, we talk about free inhabitants all the time at G10. That's what we are. Article 4 of the Articles of Confederation for the uninitiated is where we get that I was going to say word, but those words. Free inhabitant, not citizen, not subject, free inhabitant. The people are the landowners because we're the sovereigns and we created the government. The people are the landowners. And in some cases, the governments control the land, like the Bureau of Land Management. In some cases, they actually have a certain ownership to the land by the consent of the people, like where federal buildings stand and state capitol buildings, the land they're on, etc. But in general, the land is conveyed by treaty to the people for private land ownership. Constitution, Article 6, Clause 2, also known as the Supremacy Clause, bound to uphold treaties. Courts must defend land patents as they convey treaty law. Article 6. All debts contracted and engagements entered into before the adoption of this Constitution shall be as valid against the United States under this Constitution as under the Confederation. The Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties made, or which shall be made, under the authority of the United States, shall be the supreme law of the land. And the judges in every state shall be bound thereby, and anything in the Constitution or laws of any state to the contrary notwithstanding. I hate that legal term notwithstanding. It's the only place you see it for the most part, that in academia. But what it means is anything in the Constitution or laws of any state, it's secondary to the supreme law of the treaty. Treaties will be honored. It's all here. 1, 2, 3. Okay, those are the section. Clause 2 is really the most important one there. Those are the 3 clauses of Article 6. Clause 2 is the one most pertinent to us. So that's Constitution, Article 6, Clause 2. Very important. Courts of competent jurisdiction. We're going to go into this a little deeper in a moment, but Article 3 courts only. As I said, we will be going into this deeper, but it's a federal question as to when a land patent is challenged. The state courts, county courts, don't have a right to adjudicate on the federal question of ownership. So where people have failed quite often and unfortunately set erroneous case law at the state level in the lower courts is they get sued in state court by the tax assessor or whatever, the bank or whoever, and they answer the case in the state or county court, and they wind up losing, which creates case law, which gets quoted later. But what they didn't realize and should have is that court, given the federal question involved, had no jurisdiction if they had questioned jurisdiction. So very important to understand that the only court of competent jurisdiction is Article 3 court. Courts in the United States are under Article 1, 3, and 4. 3 is the judiciary. 1 and 4 are extensions of legislature. Land patent disputes that involve the interpretation or validity of a federal patent typically arise under federal law, giving Article 3 federal district courts jurisdiction. For example, cases challenging the issuance or validity of a land patent under federal statutes like the Homestead Act of 1862 or the General Mining Law of 1872 fall within this jurisdiction. Title 43, Sections 57 and 83. Certified copies of land patents can be brought to any court, but the courts must honor the patent. They cannot rule against it. Only Article 3 courts have jurisdiction to do that. Lower courts have no authority to do that. However, they not only have the authority, but they must admit the evidence by certified copy of a land patent if you bring it into that court. So if you choose to bring the land patent into a court case, you can use it to move the case due to a federal question about private property right to federal court, because the state court has to allow the certified copy of land patent as evidence. All right, lawful versus legal. Sorry, 1 second. Okay. The Administrative Procedures Act. Shoot, we don't have. Okay. That's okay. Well, this is something you guys can look up on your own, I suppose. The Administrative Procedures Act of 1946 created the rules of legal land, or it didn't create them so much as it delineated them. It made a guidebook, a code of codes of how legal land works. And what it did was it made all courts administrative, except Article 3, right? All lower courts, other than the Supreme Court, in fact, are administrative. And so administrative law came about entirely after the treaties and the land patents that are at issue, at least in the United States of America. So when we're talking about our land patents and the treaties that they derive from, that law predates the Legal Land Administrative Procedures Act and the administrative courts that resulted. So administrative law is a lower law form. It's a legal land form of pseudo law, and if presented properly in court, can be dispensed with, which will drive any lawyer and judge crazy, because that's how they operate. Okay. What it does in the administrative world is create color of title. It's administrative title without lawful standing except under contract. So contracts can be created at any time, and if you agree to a contract, then you're in the contract. But to be clear, an administrative approach to your land patent fails if you know how to stand on the law. A land patent is a lawful instrument of a God-given right. It is a right to own and hold property, at least in the United States of America and many parts of the world. And that right is a natural right. And our organic laws protected that right. In some countries, you don't have that. That right has been interfered with. But a natural right that's upheld by our organic laws and Supreme Court cannot be interfered with in the United States of America. Okay, I'm going to answer a question here. Christian, you're explaining some of these things like treaties, etc. Would you mind expanding slightly on how one might use your approach to apply this to countries like Australia or United Kingdom? Perhaps explain more of your methodology on how you approach the research so we can reverse engineer this. Thanks. Yeah, great question. So, yeah, as with all of our courses, because we're Americans based in the United States of America, the country, without the United States, the corporation. We approach things, at least for the verification in law, the American route, right? And it's true of all our courses. However, in almost all of our coursework, there are parallel equivalents in throughout the colonies, the former British colonies and Dutch colonies, etc., throughout the Western world, and somewhat in Europe. Europe is a trickier one because it in this case it came from feudal law, right? And so take jolly old England. It was that all the land belonged to the king or the queen, belonged to the crown, and if you're a duke, you might actually own land. You might have a allodial title, but in most of those cases they don't. But if you're a serf, if you're just one of the populace, you do not own land. You didn't back in the in the days of feudalism. Most of that continues to this day in England. The crown owns the land, and you just get the usufruct. The feudal system is still pretty alive and well throughout Europe. There are cases where land patents have been issued from the crown to usually other nobility, like a duke, right? And if that land patent then led to a subdivision of that land, and if that land patent granted the land with a allodial title to someone other than the crown, you can probably use this process. It will be a matter of tracing the chain of title back to the land patent to see who holds the land patent. So Europe is a less likely win on the land patent process than the colonies, which are a better chance than Europe, but will also vary a bit depending on where you are. My understanding is that Canada and Australia, for example, are good examples of places where you can trace back to allodial title ownership and through a land patent. We have not done that research yet, and I think that it would be great if you're in one of those countries to do that research over the next month or two or whatever, and figure it out. And the key things that I would look for are, number one, do you have a property right in your country? Okay. Is there a right that a right to own land or own property, right? And I'm not talking about real estate. I'm talking about, do you have a property right? That should be a fairly easy search in any country. And then you want to look from there to see what what treaties pull up, get a map of like we pull up here of how did your land come to your country? How did it come to be part of the ground that your country stands on? And if you do those two bits of research, I think we'll get much closer to answering that question. And it is a great question. We do have, I know there are quite a number of Australians and Canadians and some Europeans that have, hit me up with these questions in advance of this course. And my answer has been the same with everyone. Good chance this will work for you in your country. Nothing is certain outside of the United States of America. And I think Canada is safe to say. Canada, there's plenty of evidence, circumstantial evidence, but there are plenty of YouTubers out there talking about how they did this process in Canada. Okay, so there are others who think that it's possible. I'm not saying we should use their opinion, but I'm saying that it's out there. There are others doing it in Canada and Australia, I believe. Okay. Any other questions at the moment on there, Michael? Okay. Okay, so AI is one thing that's changed the way we approach critical thinking today since the last GTEN course that we taught. In the past 6 months or a year, AI has become so good that I feel I really should use it, if nothing else, other than to just check my thinking and work. We're going to show here what Grok says about this. Here's a prompt I gave it. I'm teaching a course on land patents in the United States of America. I know that only Article 3 courts have jurisdiction over land patents. Can you show me the authoritative law that says so? And here's the result. The claim that only Article 3 courts have jurisdiction over land patents in the United States is a common assertion in certain legal circles, particularly among those advocating sovereign citizen or similar ideologies. However, this claim is not entirely accurate or supported by clear authoritative law in the way it is often presented. This is a different answer, Michael, than when we used the other, or is it the same? Is that, it says Grok 3 here. Is that what we're using? Or is that?
Grok 3.
Okay. Okay. Let's examine the issue systematically, focusing on jurisdiction over land patents, the role of Article 3 courts, and the relevant legal framework. Now, I want to reiterate that this is a little like looking something up on Wikipedia. It is the way large language models work is that they scan everything they've been trained on, which in this case is the internet, and they look for all sources and they're looking for how often do words follow each other. So large language models are a strange beast, and it's worth keeping in mind that they are an amalgamation of thought, including the right and the wrong thoughts that are out there in print. Understanding land patents and jurisdiction. A land patent in the United States is a legal document that conveys title to public land from the federal government to a private individual or entity, effectively transferring ownership. Once issued, a land patent typically vests full legal title in the patentee, and the land becomes private property subject to state law, except in cases where federal law retains specific interests, e.g. mineral rights or easements. Disputes involving land patents can arise in various contexts, such as title disputes, boundary issues, or challenges to the validity of the patent itself. Article 3 courts are federal courts established under Article 3 of the U.S. Constitution, including the U.S. Supreme Court, Court of Appeals, and district courts. These courts have jurisdiction over cases arising under the Constitution, federal laws, treaties, and specific, there's that word, treaties, and specific categories of controversies. However, state courts also have jurisdiction over many property disputes, including those involving land originally conveyed by federal patents, unless a federal question or exclusive federal jurisdiction is involved. unless a federal question is involved. The federal question in our case is the validity of the land patent itself. That a state can't answer. Okay. The assertion that only Article 3 courts have jurisdiction over land patents likely stems from a misunderstanding of federal land law, the Supremacy Clause, or specific case law addressing federal land disputes. Below, I'll address the authoritative law and clarify the jurisdictional landscape. This was, sorry, one second. And in our presentation, there was somewhere I truncated this first one, right? We actually had it in we had this.
Yep. Mm-hmm. Next slide.
Okay, so let's go to that. So I'm going to jump to the, okay. Here are the nuggets that I pulled from this broad search that we did first. The Supreme Court emphasized, in this case, Wilcox v. Jackson, the Supreme Court emphasized that land patents, once issued by the federal government, convey legal title and are generally conclusive against the United States, unless voided due to fraud or lack of authority. This case supports the principle that disputes over the validity of a land patent typically involve federal law, making them appropriate for Article 3 courts under federal question jurisdiction. Okay. It's, you know, they convey legal title? No, they convey lawful title. But this is AI. McCormick v. Sullivan. These are the cases that Grok thinks are the most important Supreme Court precedents for the subject matter, based on the prompt I gave, right? The court held that once a land patent is issued, it is vested property right, protected under the Due Process Clause. Disputes over such rights, particularly when they involve federal law or the United States as a party, fall within the jurisdiction of Article 3 courts. However, the court also noted that administrative actions could not revoke a patent without judicial process, suggesting a role for Article 3 courts in reviewing such actions. U.S. v. Schurz, the court ruled that a federal district court had jurisdiction to issue a writ of mandamus to compel the delivery of a land patent when the plaintiff had a clear legal right to it. This case underscores the role of Article 3 courts in resolving disputes over the issuance of land patents. Oil States Energy Services v. Green's Energy Group. While primarily about patents for inventions, this case clarified the distinction between public rights, which can be adjudicated by Article 1 tribunals, and private property rights. The court noted that land patents, once granted, are private property rights subject to Article 3 adjudication, particularly when their validity is challenged. I think that's an important one. You know, if the validity of your land patent is challenged, only Article 3 can adjudicate that matter. That's a federal question. Why the claim that only Article 3 courts have jurisdiction is not fully accurate. Article 1 courts, the Court of Federal Claims, and Article 1 court has jurisdiction over claims against the United States involving land patents, particularly for monetary damages or equitable relief. The Courts of Federal Claims adjudicated claim involving a land patent dispute against the United States. So that's not particularly applicable to what we're talking about for in our instance. State courts can adjudicate land patent disputes when the issue is a matter of state law. For example, ownership disputes after a patent has been issued, or when federal law does not require exclusive federal jurisdiction. As we just saw in these other cases, a question of the validity of a land patent is a federal question requiring exclusive federal jurisdiction. Okay, for instance, quiet title actions are often resolved in state courts. As seen in cases like Summa Court v. California. We're going to come back to that one. That's an important one, even though it says here it was resolved in state courts. Whoops, I need to go back. I touched something. I don't know what. Thanks. Okay, so this is actually a mistake, an AI mistake. I can see it. Resolved in state court. No, it wasn't. It was resolved in the U.S. Supreme Court. It went to the state court, and then to the state Supreme Court, and then the United States Supreme Court. And the state court found in disfavor. the state Supreme Court found in disfavor, and then the United States found in favor of Summa Corp. So that's an important one. We're going to look at it. Administrative proceedings. The Bureau of Land Management and the Department of the Interior have authority to handle administrative disputes over land patents before they're issued. These are not Article 3 courts, executive agencies. The Bureau of Land Management is where you're going to find your land patent. So, or maybe the Department of Interior in a few cases, but generally, at least for the Western states, it's Bureau of Land Management. Maybe Department of the Interior's not, but anything west of the Mississippi is probably Bureau of Land Management holds the land patent. U.S. Constitution, Article 3, Section 2, Clause 1, grants federal courts jurisdiction over cases arriving under federal law and controversies involving land grants. 28 U.S.C. Section 1331 provides federal question jurisdiction for disputes involving federal land patents. 28 U.S.C. Section 1361 allows federal district courts to issue mandamus in land patent disputes. And these judicial precedents that we've just gone through show that Article 3 courts have jurisdiction over disputes involving the validity, issuance, or enforcement of land patents when a federal law question is at issue. Okay, so there's that's the gold. It has to do with a federal law question about the validity of a land patent and or a property right, not privilege, property right that cannot be interfered with. Those are federal questions involving Article 3 court. Okay. Right, as we saw with some other things that are not federal questions, there can be things resolved outside of Article 3 courts or by the lower courts, but those are different issues than the one at issue for us with the land patent. Okay, if properly brought, the claim is it's a federal question, which means that should you get sued in county court, that court has no jurisdiction. Okay. The choices then are to move it to federal court, and that can be done with a federal question, or to dismiss for lack of jurisdiction if they'll let you. Chances are you try to dismiss and they'll move it to federal court. But in any case, you're getting it out of the county's hands, which is good. Okay, public rights doctrine. Some aspects of land patents, such as their initial issuance, may fall under the public rights doctrine, allowing administrative agencies or Article 1 courts to handle them. However, here we go. Once a patent is issued, it becomes a private property right subject to Article 3 protection. Congress can assign certain land patent disputes to Article 1 courts or administrative agencies, as long as it does not violate Article 3's requirement for judicial review of private property rights. Okay, I have a question. My understanding, and I'm hoping you can confirm if I'm on the right track, is that what makes the land patent special is that it doesn't cite or refer to any township, county, or political subdivision of any kind in the property description. And the property description is the only evidence on record of a land's jurisdiction. And this is why lower courts don't have jurisdiction over land patents. It's not the sole reason that lower courts don't have jurisdiction over land patents, and it may not even be the strongest one, as we just pointed out, some very strong ones. However, yes, a land patent does not rely on a plat map with a plot number. Okay, it is not part of the legal fiction overlay that has usurped the country by Washington, D.C. Okay, it is not a part of legal land. It's not that fictitious veneer that lies across the surface of the land and isn't real. Land is and conveyed by land patent is the dirt, and it's measured in metes and bounds. It's not part of a county or township or a subdivision. It doesn't have any of that in the property description. It is the property description we're going to use for this process is identification of the land patent and then the metes and bounds, because the land patent's a big piece of land, right? It includes your neighbors. So it'll be the land patent, and then within that land patent territory, with the specific metes and bounds that identify the dirt and the air above it and the minerals beneath it. Okay, so yes, you're right on all counts. Thanks for the question. So then I wanted to get a little better and dig a little deeper, because I saw errors in that. I pointed a couple out to you, and so I thought, okay, well, let's think about what prompt we want to ask next. So the next one I asked Grok is, which courts in the United States of America can rule on a federal question involving the validity of a land patent and therefore a property right? So in the United States, federal courts have jurisdiction over cases involving federal questions. If it seems like I'm beating you over the head with this, it's because it's important, and the more ways we see it and look at it, and you'll understand it, including disputes about the validity of a land patent. So, when a land patent is brought into the case, which has to be allowed in, you saw the law on that. Then then a question is raised about the validity of it. If they don't accept it, they accept your land patent, then they're raising a question about the validity of it, which kicks it to federal court. Okay, because the land patent is a federal property right. Okay. United States District Courts. These are the primary federal trial courts that have original jurisdiction over cases involving federal questions, including disputes about land patents under 28 U.S.C. Section 1331. Case involving the validity of a land patent which arises under federal law would typically start here. For example, if a party challenges the issuance or validity of a land patent, the case could be filed in the federal district court where the land is associated, or the land is located, or where the defendant resides. So these, you'll notice, are U.S. code, and code is legal land. And I would argue that the land patent predating these U.S. codes actually has a higher standing than federal district court. The Supreme Court of the United States can act as Article 3 and is probably the correct place for it. If not, then you need to bring an Article 3 case in the district court, which can be done. I've done it in state court, done it in county court. Got the flags of the jurisdiction changed on the standards behind the bench, and we held an Article 3 court. And that's how I won the most important case in my life. So I guess more on that later, but courts of appeals, Supreme Court of the United States has discretionary jurisdiction if they involve significant federal questions, such as novel issues about land patent validity or conflicts between circuits. Okay. It can also get the cases directly from state courts, which was the case in Summa Corp, the one we talked about before. The state court ruled, then the state court passed it up to the state Supreme Court, and they affirmed the decision, and then it was taken to the Supreme Court of the United States, who crushed their decision and said, nope. Nope, it is not. We'll get into that. In fact, I'm going to assign it as homework. Okay. I'm going to just go to the keynotes here. Land patents are federal instruments, so their validity is primarily a federal question. See Wilcox v. Jackson, we looked at that, affirming federal jurisdiction over patent disputes. Okay. All right, let's go to the next. So then I asked Grok, is a federal US land patent necessarily a single-use document? Because you see this argument, if you go looking at someone like Ron Gibson, we're going to look at his material. He's kind of, in my opinion, one of the leaders the leader in this space. And you look at the commentary by the trolls under his videos or whatever, and it will say that the land patent is a single-use document. It conveys the land from the government to an individual, and that's it. And then the states have jurisdiction over property transfers. So I wanted to know what at least Grok thinks of that and look at why. Is it a single-use document, or can the rights, title, and interest conveyed in the land patent be passed along to successors? And here's the answer. A federal U.S. land patent is not a single-use document. The rights, title, and interest conveyed by a land patent can be passed along to successors, heirs, or assigns, as the patent grants fee simple ownership of the land. Once issued, the land patent, and fee simple ownership is not correct. It's allodial ownership of the land. Once issued, the land patent transfers full legal title, lawful title, from the federal government to the patentee, and this title can be conveyed, inherited, or sold like any other property interest, subject to any applicable laws or restrictions. And the applicable restrictions on a land patent are none. The patent itself is a one-time document that finalizes the transfer of title from the government, but the ownership rights it conveys are perpetual and transferable unless otherwise limited by specific conditions in the patent or subsequent legal actions. For example, the patent may include reservations of mineral rights retained by the government that persist regardless of transfers, but the core property rights can be passed to successors through deeds, wills, or other legal mechanisms or lawful mechanisms. Okay, so the trolls out there are wrong, according to Grok, and there's plenty of evidence for that. But this was a nice, tidy answer to a simple question. All right. For homework, we're going to look at SummaCorp. It started in California. It has to do with land in Los Angeles, Venice Beach area. It went to it found in favor of California and against SummaCorp. Went to the Supreme Court of California, found again in favor of California against SummaCorp. Then went to the Supreme Court, and the Supreme Court found in favor of SummaCorp. So the Supreme Court law is what matters here. I don't care what the state said; they were just fucking around. So what I've put here is there's the short title, the full title, and then these two links, which we will put up in the. You can write them down, but we're going to put them up in the to be formed shortly section of GTEN.org for this course. In preparation for all this and trying to fix the website at the same time, we haven't actually created a section yet for this course, but you guys will all have access to a section on this course, and these links will be in there. Also, for homework, what you need to know about land patents. I mentioned Ron Gibson before. I mentioned I hope he's doing well. He just suffered a major heart attack. He was not in the greatest of shape. He wasn't exactly taking care of himself, but he's a smart guy, knows what he's talking about. He has studied the law and land patents more than anyone, and will be a great asset to us. I was about to call him when I learned of his heart attack. So We can all say a little prayer for Ron, and hope for a speedy recovery. If I can, I'm going to get him on as a guest on this in this course at some point, subject to how he's feeling and what shape he's in, and I just hope the best for him. We will post up a copy of his book in the homework section of GTEN.org for land patents, the land patents homework section. And I would like for you guys to read it after you read Summa Corp. Read Summa first. It is there are case law citations in there. There's reasoning in there. It really is what you need to know about land patents. I look at this course. Well, I look at his inclusion in this course. Much like I look at any other author that we have included in other courses as non-authoritative, like we are non-authoritative, to be blunt. Authoritative is the organic laws, the Supreme Court decisions, Webster's and Edom Online. But I think it's worth having a good read and understanding of Ron's work because he's put a lot of work into it. It's very good. I haven't found any flaws in it. And I do hope to have him as a guest on this on this course down the road. So that's his homework assignment number 2. It's not a long book. It is a book, but it's not a long book. And I'd like you to, through this reading and also throughout the course, look for the hard questions. The critical thinking that we're doing here is trying to find better questions. We're not afraid of hard questions. We know we haven't asked all the hard questions that are out there. Nobody can or has yet, right? Even Ron. So let's look for the hard questions. And if you have hard questions that you would like to see answered, you can put them in the chat here. You can email them to us. You can save them for the next session, whatever. But get us the questions and let's address them. I've started making a list of cases that went against homeowners, and I'm hoping to get Ron on so he and I can talk about those. And also we'll be looking for primarily Supreme Court cases. I'm less interested in the lower court cases because if you bring Supreme Court case law into any court, it trumps the lower court decisions. So, let's all look first to Supreme Court cases of the United States, and also the cases in other countries. If you're in Australia, if you're in Canada, if you're in the UK or whatever, please add to your homework, do a little research to see how applicable this appears to be. And if you do the homework and raise the questions and hell, I'll let you share screens and we'll look at it together. This is meant to be a workshop. And so let's get your questions answered. Let's answer all of our questions for everyone's benefit. And if that means looking at Australia or Canada too, let's do it. If you don't have a plan, you become part of somebody else's plan. Thanks, Terrence. Does anybody have any questions? I think the best use of question and answer, if there are any in this particular session, since really I'm mostly with this class trying to raise questions, right? So we're not trying to answer everything here, but if anyone has questions about the things that we did answer, like the definitions, this is a great time. If you have any questions about how this course is going to unfold, I'll talk a little bit about it here. But if you have any questions about anything I say, let me know. If you have any questions, also, if you have any emergency in your own life with foreclosure or tax collector court or whatever, let us know and let's address your emergency if we can. As far as the procedure of this class, we're in the process of moving. Michael and I are in the process of moving out of our house in San Francisco for actually an entire month. The whole place is being painted and wallpapered and remodeled, and so we're moving into an RV on the coast for 2 weeks, and then going to see my parents for 2 weeks. So the next class will probably be in a month, probably third or fourth week of June. I would say that after that, the classes will be every 2 to 4 weeks, once every 2 to 4 weeks, with the exception that we will also have, some follow-up classes much later. And we'll do as many classes as it takes to get to the bottom of the procedure. Probably not fully looking at property tax. I think that might be a separate course, because there's a lot to look at there in the law. But we will go through the law of the procedure and the whole procedure. The procedure itself is 6 months. There's a plus the time of the title search and nailing down the chain of title and getting the land patent and all that. But we have a member, Joey, who is interested and eager to have his land be our test subject. And so we're going to go through the process with his land, and that's going to be great. Everyone's going to be basically doing it together. And that process, just to post notice and give public notice of the land patent having been brought forward, is a 6-month posting. So this course will go on. It won't be every 2 to 4 weeks for 6 months, but it will not end probably till 7 months from now, once we get the final procedure done. So we will vary the dates and times, and we will record everything, and attend whatever you can, and we'll post the mastered version of the recording up as soon as possible on the website, after each class. Yeah. Okay. So how do I access the recording so I can review it and do homework, etc.? Yep. It will, in our member portal, you'll get to the courses and you'll have access to whatever courses you've signed up for. And you'll see it in there. You'll see it appear in there. It's not there yet, but it'll appear there in the next few days, and it will have the homework in there, and it will have the recording in there as soon as the recording is ready. We do a quality master of it so that it's finalized, but then we'll get it up there without too much delay. It might take us a few days because we're moving all the furniture in our house this weekend so that painters can get in here before we move out. So anyway, might take us a few days to get to it, but yeah, there you go. Okay, great. Sounds good. I'm excited. Excellent. I'm excited too. This is a great critical thinking exercise, and we hope and presume that it will wind up with being an exercise that liberates us in meaningful ways. But we're not afraid to we're not married to a particular outcome on this, right? What my goal here is for us to arrive at a consensus together, and individual opinions on it. A general consensus on what's right and how and why. And I'm already there. I'm just sharing, with you and bringing you along. But also to look at the hard questions, do critical thinking, and okay, Joe's raised his hand. Okay, can we bring Joe on? Oh. Okay, go ahead, Joe.
Hey, Christian, good to be here. Thanks for having me.
All right, Joe, you should be unmuted. Do you want to ask your question?
Can you hear me?
I don't hear him, do you?
Oh, you don't hear him?
I don't hear him.
Oh, okay.
You guys can't hear me? Okay,
sorry, Joe, I got a technical problem here. Hold on. Okay. Joe, you want to ask your question?
Can you hear me now?
Yes.
Awesome. All right, good to be here. Thanks for having me. Just wanted to ask, and this is probably getting ahead of things here, but I like to kind of hit the ground running. So, uh, what do you think about a land patent or allodial title being acquired by an express trust or a land trust? Is it doable, or would it have to be in the name of like the human?
It is. Um, you'll probably want to do it in your own name first,
Mhm.
and then you can pass it along to any entity you want.
Got it. Okay. I appreciate it. Thank you.
You bet. All right. Is that it? Any other questions? You are a divine being. You matter. You count. You come from realms of unimaginable power and light, and you will return to those realms. Oh, there's only one quote there. I thought there were two. Okay. Yeah, I did read two. Okay, the disclaimer: GTEN always strives to uphold and honor all forms of private and public interests. Under no circumstances should you rely on the content of any information given from GTEN in determining any entity's tax or other liability, whether that entity presently exists or is to be created in the future. For all such matters, you should seek appropriate professional assistance from an attorney, certified public accountant, or other professional. GTEN does not give legal advice, nor does it prepare taxes. Void where prohibited by law. Thanks everyone for being here. I hope you have a great evening, and we'll talk in a month or so. We will email you with the next date, and we will also let you know. We'll email you when the courses are up, or not the courses. The homework is up in the g10.org members portal. Thanks. God bless.